All right, we've got about 11 or 12 people on now, and I think there are several. Oh, there's some more. Yep, here comes another one just joining us, but I think I'll get started. Again, looks like I know several people here, but for those I don't know, my name is Bill Askin. I'm at the law firm of Askin and Hooker. Um, I have been practicing primarily real estate law for slightly over 30 years now. I practice just about anything to do with real estate, residential, commercial transactions, business transactions. We do a lot of land use, like permitting and site plan approval and variances for development or improvement of real estate. We handle property tax appeals, although there hasn't been a lot of that business the past couple of years, the way property values have increased. We handle some landlord-tenant matters, leasing, commercial leasing, and issues that attain towards landlord-tenant issues. Our main office is in Sussex County, in Sparta, and we do have another office in Ocean County, in Beach Haven. The firm, we have 5 attorneys now on staff at the firm and 12 paralegals or support staff. And although my practice is limited now to real estate, wills and trusts and estates, elder law. We are a full service law firm, and we'll be happy to take a look at any matters that you or your clients might need some legal assistance on. So earlier this year, we came up with the idea to do these monthly online webinars, try to do a Q&A format. Ask Askin, right? Got the name, ask me anything. We've covered use and occupancy agreements, escrow agreements, and then today we're going to talk a little bit about foreclosures. I do kind of hope it could be a kind of an interactive chat thing. So at any time, put your questions in that chat thing. I started it off with a couple of messages in there so you can see how it works and everybody can see the messages in there. You can feel free to just chime in and tell me who you are or where you work, or just introduce yourself, or ask me anything particular about foreclosures. I'm going to start by giving a little overview. I'll take questions during my overview even, and if I don't have any questions, I'll just get a little bit more in depth as time passes. I'm happy to stay on until like 6 o'clock or even a little bit after if there are a lot of questions. I see Pietro raised his hand there. I don't know if it's Pietro or Peter. If you can chat, put your question in the chat box, or I don't know if we can turn on your microphone. Allow mic. There you go. Go ahead, Peter. Pietro. I think I turned you on. Not working.
How about now?
There you go. You're on.
Hi, Bill. Pietro here. Pietro Piccolo with United Real Estate. I do not see the chat anywhere.
Yeah, up along the very top of the screen, you should see a number of different icons that you can click on for your mic and your camera, and there's an icon there that says chat.
I see people. I see raise, react, view, more.
Mine is just to the left of people. Yeah.
Yeah, not for me. All
Yeah.
right.
All right. Raise your hand if you have questions. I don't mind turning on your microphones to do that.
Okay.
Yeah.
Thanks.
So as a lawyer, I'm often asked if I handle foreclosures, right? Bill, do you do foreclosures? And my answer is always yes. I've handled hundreds over the years, several hundred foreclosures of, one flavor or the other. And you likely have, or maybe some point you will have that same question to you, right? Right? You're in, real estate sales, and foreclosures are, often a hot topic. And I would assume if you're asked if you handle foreclosures, you'd like to say yes. And hopefully you can learn enough in your career so that you can say yes eventually. But selling foreclosures is a little bit different. The term foreclosure itself is often kind of like misused or overused or maybe misunderstood by the public. So just some basics on what foreclosure is and what it really means. It's generally used in our industry to describe 3 primary types of real estate transactions. You got You have pre-foreclosure, which happens before there's even a foreclosure complaint filed, or with storing the litigation, or it's certainly before before a sheriff's sale. There's an actual foreclosure event, a foreclosure sale that happens. That's at a sheriff's sale, and then a lot of them are actually post foreclosure after the whole process is over. First are the pre-foreclosures, and what are usually what you hear typically called a short sale. Often, would occur after a homeowner has received a notice of intent to foreclose. A lot of homeowners get that notice of intent to foreclose. They go, "Oh my God, I'm in foreclosure." At that point, they're not quote unquote in foreclosure. That's a requirement that the banks must issue a notice of intent at least 30 days before they can file a complaint for foreclosure. So it's kind of a heads up to the property owner, say, hey, if you don't catch up, bring your account to current. We have the right to file a foreclosure complaint within 30 days or after 30 days after this letter. The banks generally send those letters out about 3 months after a missed payment. So if you miss 3 months in payment, generally that's about the time frame when a bank will send out a notice of intent to foreclose. And a short sale, which I'm sure most of you have heard that phrase, and maybe you've done some short sale transactions, a short sale can actually occur at any point during a pre-foreclosure or before there's a final judgment of foreclosure in a sheriff's sale. And the foreclosure litigation, as many of you know, can last years. I mean, during the pandemic, they were lasting 4, 5, 6 years to get to a final judgment of foreclosure. And at any time during that process, you could list that property and potentially sell that property if we could get what is known as short sale approval by the lender. So they're good listing opportunities for you, as well as sale opportunities if you find properties that are listed. I think typically you'll see them marketed in the MLS as subject to bank approval or subject to short sale approval. I think that might even be required by some of the MLS systems these days. If it's subject to bank approval, you've got to put that in the MLS. But those are good. Those are good potential listings. In fact, I've seen some pretty aggressive realtors or brokers or marketing campaigns aimed at helping people in that stage of the foreclosure process. So pre-foreclosure and short sales. The second type, and this is what really a foreclosure is. It's at the end of the foreclosure process, which, like I said, can be 2, 3, 4, 5 years. It's at the end of that litigation at the actual foreclosure sale. That's a foreclosure sale, right? That occurs at the end of the litigation, filing a final judgment of foreclosure, whereby a judge issues what's called a writ of execution for a sheriff's sale. And that's the actual auction in the county seat at the sheriff's office where the property is located, where the property is sold at auction. Buying property at a sheriff's auction is generally very, very risky business. Yeah, some real bargains can be found for those that really understand the process and do a lot of work, a lot of research, and certainly some title work before that process. But generally not listing opportunities, the generally not sale opportunities either, unless you're an expert in the process and maybe you work with an investor and your investor is willing to pay you, or somebody's willing to pay you, because the sheriff's office, they don't pay commissions at a sheriff's sale. There's no way to get paid by the sheriff. And of course, if your broker approves. So I know we have at least 1 or 2 brokers on here tonight. Make sure you talk to your broker before you ever want to try to get paid by somebody and represent them at a sheriff's sale. So we got pre-foreclosure, short sales, actual foreclosure sale or the sheriff's sale, and then the third type of transaction that's often referred to as a foreclosure is actually after the process. It's a post foreclosure or after the sheriff's auction, when the real estate at that point is actually owned by the bank or by the government, right? The FHA or VA might own the property, or the IRS if it's a tax foreclosure. And those properties are what are known as REOs. And if you want to get a little bit of education, type foreclosure listings into a Google search, you'll get an awful lot of them. You'll get thousands. Most of those you'll find in there are bank-owned properties or government-owned properties, HUD properties. So those are the the various stages. I'll get into a little more deep dive now into each one of those. And again, if you have questions, just raise your hand or type your question into the chat box if you can find that. I understand that's not easy to find tonight. So let's see. At the different stages of the process, there's different entities that may actually be in possession or actually control of the property during what, as a group, these are called foreclosures. And yes, there are many steps along the way that you can assist with as a realtor. You know, could be listing the property for an owner in pre-foreclosure or representing a buyer in a short sale. When the court is in control following a final judgment of foreclosure, like I said, the sheriff is technically in control of the property, and there's likely not an opportunity for you to assist a client, but you can assist after the sheriff's sale when the property is then owned by a bank or the government. And those are called REOs, another technical term that you may or may not have heard of. REO stands for real estate owned, REO. That's real estate owned by a bank or the government, or the IRS even owns some properties, and all those entities like to get rid of them quick. They're not in the business of owning real estate. That's the last resort from that for them. They would much rather approve a short sale, approve an owner occupant selling the property short of what is owed on the property, or even having somebody else pick up the property at a sheriff's sale. But if push come to shove, they have to buy the property at a sheriff's sale, they eventually will, and they will then become REOs, and that's very troubling for the banks and the government. They're not in the business of being landlords or property managers, and it costs them a lot of money and lost revenue. So each of the different scenarios has its own risks, its own opportunities. You know, the best opportunity is probably a sheriff's sale, but that's by far the highest risk. Very, very difficult. A lot of risk with sheriff sales. You can't get into the properties. You can't inspect the properties. The sheriff doesn't ensure the title to the properties. It's possible if you don't do a very thorough title search and chancery abstract. It's important if you're going to get into the business of sheriff sales and working with those, you've got to not only work with a very good qualified title company, but make sure they not only do a title search, but that they do a chancery abstract to confirm all the liens are paid up, that the chancery abstract is the history of the foreclosure litigation, to confirm that everything was done properly, that the judge signed all the appropriate paperwork, and that the sheriff has the actual legal authority to sell the property at auction. If you don't do all that type of stuff, and I've had clients do this, buy a property at a sheriff's sale, and unbeknownst to them or anybody, there are other liens on the property. There can be mechanics liens, there could be lines of credit, second mortgages, judgment liens. The sheriff doesn't look at any of that stuff. The sheriff looks at the order from the judge to satisfy the lien, generally by the first mortgage lender or the bank. Sometimes the tax liens, or usually the tax liens, come up and they get handled. Usually a second mortgage would come up and that would be addressed. But in general, they don't do a search for judgment liens, mechanics liens, any other possible liens or encumbrances on the property, and they don't do a title search. So as a group, you may have heard this also, that these types of properties are referred to as distressed properties. They're distressed because of two things, right? So first, because of the financial situation. Obviously, for some reason, the owner occupants were no longer able to make the payments, no longer able to afford the property or to stay in the home. And as a result of the financial distress, that also often leads to physical distress. And they're distressed because potentially the physical condition of the property. One thing to be wary of in any stage of foreclosure, you know, those properties often have deferred maintenance, lack of maintenance, lack of upkeep, and in some cases, even actual intentional destruction by the property owner. And I'll cover that again in a few minutes. Make sure your clients know that. You know, if you get a buyer looking at whatever it is, a short sale, a bank-owned property, whatever, that they're often treated poorly by the owner or the former owner. You know, generally it's, you know, they're upset, right? They're being forced by the bank or by the courts or by the judge or by somebody. They're being forced to leave their home where they invested their life's worth or life's work and investment and they raise their kids. And in this kind of business, people get angry sometimes, and chances are, if they get angry or angry at the bank, they can't pay their bills, they may take stuff from the property. They may remove appliances, the copper plumbing. They even situations where they've actually done physical damage to the property. So be wary of that. Um, you know, Owners unfortunately feel that sometimes lenders do act in bad faith in pursuing these cases. Maybe the lender was a bad faith lender, taking advantage of people. Who knows? But I've seen everything and anything happen in this business. So the damage that can be caused can range from the superficial stuff to like we said, damage of structural elements of the home. So just be critical. It's critical that you and your clients understand all that. Some of the basics of foreclosure and working foreclosures, if that's something that you might want to incorporate into your career. During the pre-foreclosure process, before the foreclosure litigation has either been initiated or concluded with a final judgment of foreclosure, know that the property owner still has control of that property, right? They still have absolute control of it. They've got occupancy of it. They control the ingress and egress. They have the keys. They have the ability to make improvements. Unfortunately, they have the ability to not make improvements or not take care of the property. And they have the ability to list that house with you and sell that property to a potential buyer at any point up until the final judgment of foreclosure, right? And we've actually closed properties for realtors and buyers and sellers the day of the foreclosure, scheduled foreclosure. Another thing to keep in the back of your mind is that if you have a seller that ends up in that situation and you're working on a listing or working on a contract or trying to get something on paper to present to the bank, the homeowner has 2 free adjournments of the scheduled sheriff sale. So the sheriff sales, the property owner gets notice of the scheduling of the sheriff sale. All they have to do is call the sheriff's office and say, hey, I want this to be adjourned. And if it's the first request, it will be adjourned, no questions asked. If it's a second request, it'll be adjourned, no questions asked. The third request, you have to have a verifiable, reasonable excuse to have that sheriff sale adjourned, or you need the lender's agreement. So either one of those ways, you could possibly get more than 2 adjournments of a sheriff sale, but 2 are a given for any reason or no reason at all. So keep that in mind. It's important to know that as well. Any buyers can make offers to purchase the property during that time, but know that if you're working on a short sale or a pre-foreclosure, that the contract must have a contingency in it, making it contingent upon bank approval or contingent upon short sale approval. Just put that in the last paragraph on the realtor form contract, additional conditions. Just put that in there, and the lawyers will work out the details of the timing for short sale approval. Generally, you don't want a buyer hanging out there where there's no date by which the seller has to get short sale approval. So if you just leave it open, potentially a buyer could be stuck to a contract for a year or more, pending short sale approval. So I would always recommend, and I would talk to the buyers about this, that you put a time limit on it so that if another property comes up that they want to buy, they're not stuck to this property. So subject to short sale approval, and either buyer or seller can terminate this agreement within, if short sale approval has not been attained within 60 days or 90 days or 120 days. Oftentimes it's best, if possible, if you're the listing agent, to get the short sale approval process started or initiated when you take the listing. Don't wait until you get an offer. Get in touch with the bank, with the lender immediately, and request a hardship package. the hardship package for short sale approval. And there's a lot of the work that both you and the homeowner can do ahead of time, and then the attorneys will get involved once there's a contract in place. So there's a lot of stuff you can get from the bank to get that process started and make it go a lot quicker once you have an offer. And then such a sale, if it's approved by the lender, that helps a lot of people, right? That helps, people in the business of selling real estate, survive, make a living, make a commission. Helps the seller avoid foreclosure. The blemish on their credit helps them move on with their life. The ding on the credit is a lot less for a short sale than it would be for a foreclosure. Usually translates into a fairly good deal for a buyer, at or below market value typically. And it also helps the lender. It also helps the bank. And banks in general, most of the time, are very cooperative with these things. It takes time. It can be like pulling teeth to get the approval, but the bank wants it just as much as the buyer and the seller want it. It helps the lender control their costs by avoiding the foreclosure process. And believe me, banks to foreclose on a property, takes a number of years. And you all know, working with lawyers that do that kind of work, it's very, very expensive. And it helps the lender by creating an avenue of relief where the lender doesn't have to take ownership of the property, right? So they avoid the time, the ownership, the legal fees, the insurance fees, and then eventually the time of managing that property, cleaning the property out, fixing it up, listing it, and trying to sell it on the open market. They would much rather avoid all that and work with us to create a short sale if possible. Another advantage of short sales is that, typically they're in better condition, right? So you're not going to have a sheriff's sale or a bank-owned property where somebody got really mad at the bank. And short sales, the people generally are still living there. Oftentimes, by the time it gets to sheriff's sale, the property is empty, it's vacant, it's been neglected, and it's been moved, potentially destroyed. So short sale homes generally are in the best condition out of the three different types. Um, um, Also, with a short sale, it's really the only one where the buyer is going to have unimpeded access to the property, right, to do their inspection. With sheriff sales, there is no way they can get in the property, right? The sheriff can't let them in the property, right? If the homeowner is still there, they're angry, they're not going to let anybody in the property. And if the homeowner is not there, the property's been secured by the lien holder, by the lender. The property's been locked. Maybe the windows are boarded up. You're not going to get in before a sheriff sale. So that's what makes sheriff sales really risky. Short sales, less risky because you can get in, get a full inspection. There may not be, or there likely won't be, any money on the seller's part, right, to handle any repairs. You can ask for repairs. I can tell you what, you're not going to get any credits because the lender, the lien holder, is not going to permit any credits on the HUD. So no credits from the seller, probably not any repairs either, but at least your buyers, if something bad comes up, something detrimental, real big defect in the property, at least your buyers can get out of the contract. They won't have to go through with it. So, but for better or worse, homes don't always sell during pre-foreclosure or short sale. Sometimes there's just no buyer for the property. Sometimes the gap is just too big between the property value or the property value as compared to the amount of money that's owed on the property. Sometimes the owners just put their head in the sand and they don't want to cooperate with anyone. We do have an occasion where the lenders just won't approve a short sale for some reason or another. They think maybe the owner's got money somewhere else. They're going to make money out of the owner from somewhere else. And if that happens, it goes all the way through the foreclosure process and ultimately to the judgment of foreclosure, and then the writ of execution for a sheriff's sale, or at which time it'll begin the process of being transferred over to the sheriff, and you'll start seeing postings for sheriff sales. It's important to note that during the sheriff sale process, the lender now cannot take advantage of the property owner in any way, nor can the lender make a profit at a sheriff sale, right? So when the property is sold to the highest bidder at a sheriff sale and all the liens are paid, anything left over at the end is actually given to the homeowner. So if there is excess funds from a sheriff sale, the homeowner might get a little bit. That's very rare. Typically, once all the loans are paid, there's some other money that can't be paid, and that's what is forgiven. That's the forbearance in the sheriff's sale, and generally there's no money left. If you're really interested in or curious about the sheriff's sale process, I would recommend going to a sheriff's sale. They happen every week in most counties. Some counties they might be every other week. I think generally on a Wednesday. At the generally at the sheriff's office. If you just Google sheriff's sale for Atlantic County, it'll all come up. Location, time, days of the week. It's a good thing to just go visit and see it. Generally, there's not a lot of people there, but there will be several people there, and those that are there are professionals. They know what they're doing. And there also will be a representative there, potentially representing a number of different lenders, but the lenders share the representatives that they send to these auctions, and the lenders are there to protect the lender's interest. So if the property is not occupied, the properties at this point are generally they're winterized to reduce the risk of damage to the property. The plumbing's drained, the hot water's turned off, the heat's probably off, and there's really no way to inspect those properties. It's really very rare that you can ever even get in one of these properties prior to a sheriff's sale. Sheriff's sales are very strict. They follow a set of rules and guidelines and a script. They're all the same throughout New Jersey. It's an open auction. There's no sealed bids, no warranties, no insurances, no title insurance. All the sales are what's called caveat emptor or buyer beware, and the properties are sold to the highest bidder at that auction. 20% of the bid price, 20% of whatever the highest bid is, must be paid by the purchaser at the auction. So how do you do that, right? And it's got to be paid either in cash or in a certified or cashier's check. So most of the professionals that do this for a living, they bring a number of certified checks in varying amounts to the sheriff's sale, so they can have enough money to make that 20% down payment, which has to be paid that day by check made out to the whatever county it is, Ocean County Sheriff or Morris County Sheriff. In fact, if the buyer or the winning bid doesn't make that payment that day, the sheriff can immediately put the property back up for sale again, and the original purchaser can be held liable for any deficiency, right? So if I go in and I bid $200,000 and I'm the winning bid and I don't have $40,000 to put down, it goes back on the auction block, and when it sells for $160,000 the next time, I have to pay the $40,000 difference. I'm liable for that. So that's why I said it's pretty sophisticated and risky business if you don't know what you're doing. The balance of the purchase price is due within 30 days. So after the sheriff's sale concludes, the winning bid is $200,000. I pay my $40,000 down. The balance of 160 is due within 30 days. And you can't get a mortgage, right? So you can't just show up and say, well, here's a mortgage from Bank of America. You need to have the balance in cash. You can get money from a hard money lender. You can get a line of credit on another property, but you can't get a mortgage on the property that you're buying at sheriff's sale. And it's due within 30 days after the sale. And if you don't pay the balance due within 10 days, interest starts accruing. So they want their money within a little over a week after the sheriff's sale. If you don't pay it within 10 days, the interest starts accruing on the balance owed until the 30th day. And after the 30th day, the sheriff again has the option to re-advertise the sheriff's sale and selling it again and hold you liable for any shortage or difference between what the original purchaser had bid to pay for the property. Important to note, the property owner, even after a sheriff's sale, has what's called an equitable right of redemption. And for 10 days after the final bid, the final sheriff's sale is done, after somebody purchased the property at auction, for 10 days, that property owner can come back and redeem that property. That means they have the lawful right to come up with all the money that's owed, to bring the mortgage to current, there's a final judgment amount. When there's a final judgment of foreclosure, there's an amount of money That's the amount of money the property owner could bring to the sheriff's office within 10 days and redeem their property and keep their property. So that's a risk that happens sometimes. In fact, that 10-day equitable right of redemption can be extended upon showing of cause to the Chancery Court. So I've actually handled several of those for unknowing or unintelligent, perhaps, or unknowing homeowners who pled their case, and we got the 10-day equitable right of redemption extended to allow them to redeem as much as even like 30 days after an auction. The purchaser will get a sheriff's deed eventually. If there's no equitable right of redemption within 10 days, after 10 days, they pay the purchase price in full, and they will receive a sheriff's deed from the sheriff, and it's the purchaser's obligation to record that sheriff's deed in the clerk's office. So there's a little bit of extra work that needs to be done. It's not like a typical closing where everything happens right at the closing. You know, a sheriff's sale, it's an auction. You pay your deposit, you pay your balance due within 30 days. Once that's paid, then the sheriff will give you a deed a few days after that. Then you need to take that deed and record it at the county clerk's office. Further challenges or difficulties with sheriff sales are a lot of the properties that people buy are occupied, right? So there could be the property could still be by the previous owner or occupied by the previous owner. In such a case, you need to go to court and get a judgment of eviction. That would take no more than about 30 days. It's actually an ejectment proceeding. If the property is owned or is occupied by a tenant other than the former property owner, if it's a tenant, then you're subject to the New Jersey Landlord Tenant Act, and you would have to file for eviction. And that would take a little bit longer. That could take 60 to 90 days, but as long as the purchaser intended to occupy or sell the property to an owner-occupied individual, they would have just cause for an eviction of that tenant. If you didn't do a title search before buying a property at sheriff's sale, shame on you. When you go to sell that property, it's for darn sure the buyer's going to do a title search, and hopefully that buyer ultimately is not going to come up with other liens that were not paid off or satisfied in the foreclosure process. Again, another risk, I've seen it happen. Again, unknowing purchasers didn't do the proper title search and chancery abstract search. They bought a property, fixed it up, they're ready to sell it, and the buyer does a title search and finds out there are outstanding mechanics liens and judgment liens against the former owner. Those now become the obligation of that person who bought it at the sheriff's sale. So very, 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 very risky proposition. But oftentimes there's so much money owed on these properties that nobody bids on them, right? Go to the sheriff's sale, nobody bids. What happens? The bank or the lien holder takes the property back for what you often see, $100, right? You see the deed transferred back to the bank for $100. That's generally a property that is so underwater that there's no buyer out there that would be willing to take it on and pay more than the bank would be willing to pay to protect their investment in that property. So if the banks take those properties back, nobody's willing to bid on them. Maybe there's a number of different liens. Maybe there is a lot of deferred maintenance. Maybe it's just that the property, the debt on the property is $500,000 and it's only worth $250,000, and it just, you know, the bank isn't willing to walk away from $250,000 in equity, so they take the property back. That now becomes what's known as REO, or real estate owned. Full possession of the lender. It's probably the most popular method of buying foreclosures, probably what most consumers think of, or most potential clients are referring to when they want to work with you to buy a foreclosure. They're really, in most cases, talking about REOs, or bank-owned properties, or HUD-owned properties, or FHA-owned properties. And there are a lot of ways to find these properties, a lot of ways. Just Google it, right? You'll find all kinds of listings. Some brokers and realtors specialize in handling listings for banks, right? So you make a good contact at a bank with an asset manager at a Wells Fargo or JP Morgan or Bank of America, or one of the management companies out there that manage all these properties for the banks. and literally realtors do nothing but list foreclosure properties for these institutions. It's a great way to make a heck of a nice living. But as a realtor, you have to sign not only listing agreements but property management agreements. Banks want you to be involved in a lot of cases, securing properties, working cash for keys, trying to get tenants to just agree to leave in exchange for some money sometimes, fixing properties up, maintaining the properties, listing the properties, and ultimately getting them sold. It's a great way, like I said, if you're interested in doing that kind of work, if you can get some connections, talk to some people in the industry. I think it's probably a very big part of what's to come in the next couple, 3, 4 years in the real estate industry. You probably know there have not been as many bank-owned properties or foreclosures since 2019, since the pandemic. The courts were basically shut down. There were no foreclosures. There were no final judgments of foreclosure. There were no sheriff sales for a couple of years. So there's a lot backed up in the system. I think there's going to be a slow, steady release of additional bank-owned REO properties. I believe that's one of the things that's going to eventually drive prices of real estate back down again to some normalcy. I think what we're seeing right now is very abnormal, obviously. And I think somebody's going to make a lot of money listing and selling bank-owned properties. So I'd look into that. I think short sales is probably a few years off yet. I think that's going to come back. I don't know, 3, 4, 5, 6 years down the road now, and I feel confident that opportunity is going to come back as well. And here's why: I think the past several years, a lot of people vastly overpaid for property, right? Vastly over mortgaged property, and got locked into mortgage rates that they're not going to be able to afford. So I think that short sales we're not going to see a lot of the next few years, but we still do a few every year. We're still doing some short sales and some bank-owned properties, but I think this is probably good target business to look at if you're going to look to build your business over the next several years. Now that the lender owns the property, they no longer have to protect the property owner, right? So they can sell it for whatever they want. They could sell it for a lot more than they paid for it. They can keep the profit if they make money on it. That's not very common, but it's for the lender to do what the lender wants to do with it. Generally, lenders, again, they want to move these distressed properties off their books immediately or as quickly as they possibly can. Generally, you'll see that the lenders list them at prices that are pretty close to market value. They're not looking to list them for high prices. They're looking to make it competitive and get them sold quickly. Another benefit is the lender will be required to clear all the liens on the property. So, like at the sheriff's sale, there is often unknown other liens on the property. When the lender owns the property, the buyer comes in, the lender has to clear any other liens, tax liens, mechanic liens, judgment liens. So the buyer can get fully insured title buying property from a lender. Banks must almost always use their own form of purchase agreement. So be very wary of that. Typically, when a lawyer gets the contract, it starts with the realtor form agreement. It's presented to the listing agent, who presents it to the bank, and then the bank counters with their own agreement. And it's generally a pretty long agreement. It's smaller font. It's harder to read and won't be as familiar to you guys. That's okay. It's still subject to the 3-day attorney review contingency and subject to your client's attorney's review and approval. Unfortunately, the opportunity I generally have to protect my clients is an opportunity to explain to them what that addenda means. That addenda means, but if I do try, if I make any proposed changes in my attorney review of that that lender's addendum to the contract, they're very unlikely to accept any changes, unless it's something very minor, like a closing date, or maybe a number of days for inspections. They're very strict in the terms of their their addenda, which are drawn by attorneys. And then when I get to it, I'm dealing with like an asset manager who doesn't have the authority to provide legal advice. So like, nope, that's our addenda. We don't change it. So they will also, the banks also will likely offer to use their title company. They've used a title company in their process of taking the property back from the former owner. They've run title search. They've run liens and judgment searches. They've got all the title work. They have agreements with title companies that do all their title work, so there are discounts available. Often you'll see in those addenda that they are willing to pay for the owner's premium for the owner's title insurance. Can be a big savings for the buyer, right? If they take advantage of that. So that's another opportunity with that. They will likely require a pre-approval. Most all banks will require that your client be pre-approved and documented pre-approval. They'll limit the inspections. They'll say that the inspections are for your client's information only. They're generally not cooperative in making repairs or improvements or putting in a new furnace or anything. They typically fix up the property when they take it back to the maximum extent that they're willing to fix it. They put it on the market, and then they say it is what it is. Caveat emptor, buyer beware. You can have an inspection. At the end of the inspection, you either go, I'm moving forward, and you satisfy the inspection contingency and remove it, or you terminate. That's it. That's it. It's one or the other. So again, make sure your buyers don't have high expectations that a bank, right, is going to do all kinds of repairs or credits. Same with short sales. You know, it's a different negotiation, and you have to make sure the buyers are aware of that ahead of time, not to come in and expect, well, my neighbor, he just bought his house and the seller fixed the furnace and the roof and the water. That's the neighbor. That's a person. There's a different motivation there. There's a lot of emotion in person-to-person transfers. Sheriff sales, bank sales, even short sales with lender approval required. You're dealing with a bank, an unemotional committee. It's not even a person. They don't care about how much you love the house. It's just a business deal. It's more like selling commercial real estate in these types of transactions. So, but most important to know is these deals, these transactions, they're not standard. They're different, and make sure you get some help with your first one or your first couple of three of them if you haven't done this kind of work before. The banks also will not allow any contingencies, right? So they'll allow a home inspection, they'll allow a mortgage contingency, but no home sale contingencies, right? So if your buyer has to sell his current home before he can buy an REO, forget about it. Not going to happen. Another idea for short sales or for REOs, a lot of REOs, you can finance most of these properties with an FHA 203K loan. They do allow that. So if it's a property that's bank owned or even potentially a short sale, and it needs a lot of work, talk to your favorite lender about an FHA 203K or a conventional fix-up mortgage, a conventional renovation mortgage, sorry. Those are great products for these types of properties, and the banks they're very cooperative in that kind of a thing. Most lenders will not allow a transaction to close unless all of their requirements are met. The property be transferred as is, like I said, caveat emptor. There's no seller's disclosure. Another important thing to note. You're not going to get a seller's disclosure at a sheriff sale. You're not going to get a seller's disclosure buying an REO. These are entities that never lived in the property. They don't know anything about the property, and the law doesn't require anybody to make a disclosure. Do that, but the disclosure requirement is a NJAR, Association of Realtors, and it's a good rule for realtors. But the law, if you're a FSBO, nobody's going to make you complete and sign a disclosure. So ultimately, obviously, three different kind of flavors of foreclosures. I would encourage you to learn more if you're interested in doing this type of work. I'd like to take some questions. I was hoping to get some more questions. I didn't see any during the presentation. If you have any, I'm happy to stay on for a while. If you want to raise your hand or type something in the chat box. If not, if anybody has any suggestions or requests from for other topics, we do these once a month. I see Pietro and Mohammed have questions, so let's see. Pietro, I'm going to. I think I disabled your mic, Pietro. Can you turn your mic on, Pietro?
Yes, sir.
There you go. Good.
I have a question, but it's not foreclosure related.
Okay.
I don't know if you wait until everyone's done and then ask it to you.
No, go ahead. I only have 2 questions so far, I think so.
Okay. So my question is a variance. Okay. So I bought a property that is mixed use last summer. All right. And it has a huge parking lot. I have one tenant who is a tow company dispatcher. The town does not allow a flatbed truck there. So I'm a little naive here. To me, I think there's enough space to house that truck and others, but I guess it's just the usage.
Yeah, if it's in the code, they're not allowed to have a flatbed truck, and that's one of the unique, foreign things to lawyers, right? So we're all about the law, right? The rule of law. You get the criminal code, you got the civil code, you got all these laws that if you break the law, you get in big trouble, and there's no flexibility, right? If you can't change the law, there are no exceptions to the law, except for the zoning code, right?
Yeah.
So the zoning code is designed to, manage and control the neighborhood schemes and the districts in every municipality in the state of New Jersey. And in that particular instance, that zoning code for I don't know what zone that property happens to be in, but it is multi-use, so it must be in some kind of a business or commercial zone. The code, the code there says no flatbed trucks are permitted to be seen from the street, probably, right, or to be in the parking lot. And you can go to the zoning board and apply for a variance to allow your tenant there to have that truck in the parking lot, even though the code says you can't. That process is called a variance. Now, the chance of getting that variance approved by the zoning board depends upon the makeup of the zoning board and really the politics at the time in the town. But if they did approve it, or if you wanted to make the best case for getting it approved, you would want to demonstrate how you can minimize the negative impact of having that truck on that property, right? So the negative impact is probably the space available for the truck, the view of the truck. It's probably big, and they don't want to see big trucks in the parking lot. So you would want to create a space for that truck and some fencing, right, or some barrier to hide the truck, whether it's a row of trees or a garden or a fence or something, so it's not seen from the street. If you could come up with something like that and present it to the zoning board, they might just give you a variance and say you don't have to comply with that part of the law. All right.
Okay, thank you. Appreciate that.
All right, Mohammed, I'm going to jump to you here. I'll try to turn. Let me see. Allow for mic. There you go. Okay.
Can you hear me?
Yep.
Okay. Yeah, I have a client who's actually same thing, buying a mixed use properties, and there's 3 tenants in there. I want to try to just recommend to him whether to buy it and have the tenants out, or just they're actually on a month-to-month basis. So would you recommend buying it after the tenant's completely out, or just being that there is a month-to-month, we could just...
Is it residential or commercial?
It's a mixed use residential, and the office space on the first floor.
Office on first and 2 residential units above?
3 units upstairs, yes.
And does he want all of them out?
Well, no, I'm just trying to figure out that would it be wise to have him do the closing and have the tenants notified to be out before the closing, or no?
It depends. If he wants them out, if he wants to do a lot of improvements to the property and get new tenants, he should have the tenants out before closing, because otherwise he's taking on the burden of evicting those tenants, right? So you probably know something about landlord tenant and evictions.
Yes.
It can be impossible. It can take a long time, or it can be impossible.
They're on the month-to-month basis.
So even the residential tenants are protected pretty much for life, right? Unless they breach the lease, or unless they're criminals, or they don't pay the rent, right? or unless the property is sold to an owner who wants to occupy the property. So if this guy himself wants to occupy one of those residential units,
No,
he could.
no, it's more like for a business.
You buy it subject to the leases then.
So just tell him to buy it and have the tenants move out before
Yeah.
the.
Have the
Okay.
seller handle it, the evictions to get the tenants out.
But what that will take make the selling process longer, right? Take longer.
It depends. You know, it would take at least 60 days. It could take a year or more. It may not even be possible,
Oh,
right?
well,
Month-to-month tenants. You buy
because the
buy real estate subject to the existing tenancies.
yeah, because the buyer is interested in the property, but and he wants to make it, like close it as soon as possible. But then with this issue with the tenants, we're not sure which route to go with, whether have him evict them or have him, buy the property without the
Yeah.
tenants,
Yeah.
or just to make it quick,
Yeah.
take the property in
Yeah.
with the tenants and then notify the tenants, I guess.
Call me offline tomorrow if you want, if he needs some help, unless he has an attorney already. Yeah.
Okay, yeah, I'll take your number and then I'll give you a call.
Yeah. Yeah. Do you have my number?
Yeah, just give it to me just to be on the safe
Yeah.
side.
973
Mhm.
729
Okay.
7711.
Okay. Now I have
Alright.
another client that's actually there. He's interested in buying the bank owned property because he got hit with the sheriff's sale and he got screwed big time. So now he learned a big lesson not to bother with the sheriff's sale. So talking about sheriff's sales. Yeah. What's the best way to go, like find the bank owned properties that I could help him with?
Bank-owned properties, most of them are listed in the MLS. But you can
Oh,
also look like government-owned properties you'll find on things like auction.com.
okay.
And literally, I did it earlier this afternoon just because I was curious to see the activity. There are hundreds of sites where there are auction.com, where
Yeah,
HUD
I
has
looked
auctions.
into auction.com, but those are
And
areas to look.
yeah, and tell your clients to type your name in when they're making the bid because they do
Yeah.
pay commissions. Yeah.
Yes. Okay.
All right.
Okay.
Lori, I turned your mic on. Lori Mantilla, I think you have to turn your mic on now.
Hi, Bill.
Hi, Lori.
Hi. Question. Now, when you're talking about the stages of pre-foreclosure, foreclosure, with the sheriff's sale, what if you had to just do a guesstimate? Is the time frame for each stage?
Really good question. Yeah. So pre-foreclosure, from the time, let's see. So somebody misses a mortgage payment, you get 90 days or so. They get the notice of intent to foreclose goes out. Then the bank can't file a complaint for foreclosure for at least another 30 to 60 days. You're talking that's 6 months. From the time a complaint for foreclosure is filed until there's a final judgment of foreclosure can be anywhere from 9 months to 5 years. And
Wow.
it varies a lot by county and by the backlog in the county. Right now, they're taking quite a bit of time, and they're taking a couple of years, at least a couple of years. So, and
So
anytime
just in
the
the
seller has control of that property to sell that property via short sale.
Wow. And you're talking about just in the pre-foreclosure stage.
Pre-foreclosure is the entire time up until the point where a judge issues a final judgment of foreclosure.
Okay.
Now, pre-foreclosure, then judgment of foreclosure, sheriff's sale, then post-foreclosure or REO.
Okay, and then it goes to REO after that. All right.
Correct.
Now, we're talking about REO. I know you had said it was, hang on a minute. You had said it's bank-owned, government. What were the other entities?
Well, I mentioned the IRS. Once in a while, you'll see like a big tax lien on a property, and the IRS will foreclose on the property and actually own the property. Don't see it very often, but that's the IRS. And it can be any lien holder, right? It could be a mechanic's lien could foreclose if there's no other bigger liens on the property. Again, doesn't happen very often. Usually those guys, the mechanic's liens and the judgment liens, they get paid off when somebody else buys the property. They don't foreclose themselves.
When something goes up for the sheriff's sale, right? How long does it take to get to the sheriff's sale? Or that just depends on the pre-foreclosure, that could be years.
No, it's generally months after the final judgment of foreclosure. It'll happen within a couple, 3 months after the judgment of foreclosure. But remember,
Okay,
then the property owner has those 2 free adjournments. And the
right.
banks, the banks adjourn these sheriff sales even more than the owners do. The banks
Yeah.
adjourn them all the time because they hope that somebody will come and buy these properties. They don't want to own these properties.
And I had one other question, but that's okay. I don't want to hold up
Yeah.
anybody else. You can,
Yeah, that's all right.
I'll
I
think-
see Doug, you have your hand up. I think your mic's on. Doug Radford. Oh, Doug, I can't get yours. Doug, can you type your question in? I can't get your mic on for some reason. Anybody else? I don't see anybody else. Yeah, good. Mohammed, are you on?
Yes.
Yeah.
Yeah, you mentioned something about get an abstract. That would be a safe way to check if there's any liens. How do we go about getting the abstract?
Through a title company.
Just contact title company.
Yeah, they do it all the time. So just when you order your title report, also order a chancery abstract.
What is it?
Chancery abstract.
Transfer abstract. Okay.
Yeah.
Okay. That's normally separate, right?
It is. It's different. It's searching court records. Like
Okay.
it's searching the litigation file as opposed to the chain of title.
Do you know roughly what they charge for something like that? That's like
A couple $100. It's not expensive. Yeah.
Oh, okay. But it's wise to do it so this way, if there's any lien, all comes up.
Yep, the searchers, the examiner will tell you if it was done properly. Or a lawyer looks at it and says, yeah, this was all done the right way.
Okay. So the
They
title
want to,
company
generally, they want to look at it and make sure that all of the lien holders have been included in the foreclosure process, right? So they want to make sure that the municipal tax collector was included in the foreclosure case if they have a lien.
Yeah, I had a case where actually the day of the closing, they decided there was another lien just came up just right on the closing date, and we had to postpone it and kind of reconfigure everything out.
Yep.
Okay. All right.
All right. Lori, did you have another question?
Yes. So I was involved in a short sale where at the 11th hour, I mean, we're all getting ready to close. At the 11th hour, the IRS came in and they had some unbelievable,
Yeah.
it actually happened to be a kind of a famous sports figure, but whatever. And the IRS came in and had a big lien on it. So it then changed from a short sale, I guess. Then it went through the proceedings of foreclosure. Then, if they were too underwater.
So I don't know what happened. Did it close or no?
No.
No.
No,
Okay.
there was it went to way more than what was owed on that, like what the house was worth. After this big IRS thing came in. Why would that come in at the 11th hour though? Why wouldn't that come in way earlier?
Because the IRS was owed a lot of money, first of all, like you said. And second of all, they got wind somehow of this potential sale happening, and then they filed a lien very late in the game, which they can do and have done on sales of mine. But the IRS also is very reluctant to actually own properties, right? So they're although they're somewhat challenging to communicate with, if you can get to the right person at the IRS, they're very willing to negotiate their liens as well.
Okay.
I've negotiated some 6-figure IRS liens.
That would have to come from the seller's side, not the buyer's side.
Correct.
Okay.
Yeah.
I had the buyer, so.
Yeah. Yeah, the
That's
seller's
really good.
attorney would do that. Should do
Okay.
that.
Thank you, Bill.
You're welcome. And Doug, I think I turned your microphone on if you're still there. I'm not sure why. You can call me, Doug, if you have a question. Yeah. All right. Any other, throw this out there. We're going to do this again next month. Any other topics? We've done escrows. We've done use and occupancy agreements, now foreclosure. You know what? I could do one on land use and zoning and variances. Go ahead, Mohammed.
Yeah. Okay. One more questions about the properties. Now, if there is like the property, I'm not sure if they allowed to go like make a third floor, and they told me that actually it has to be like by application, but we won't be able to. So is there any way that we can find out if that is possible beforehand? Or
Yeah, Mohammed, you're breaking up pretty bad. I can't understand. I'm not
Yeah.
coming through.
yeah, I, you know,
Is it, I don't know if it's me or if it's you, but I think you're losing your signal.
I can't hear anything either.
Yeah. Brenda. Oh, I can't turn you on. You know what it is? You're not using a Doug told me you don't have a Teams. This is a Microsoft Teams thing, so you can listen, but you can't ask questions if you don't have Teams. So Brenda, you also have my phone number. You can call or text me whatever question you might have. Go ahead, Mohammed. You look like you have connectivity again.
Okay. Yeah, I was asking on the deal I'm actually working on with this buyer. There's a potential possibility that they could raise the building to like a third floor, but someone was telling me that actually you can't do that until they buy the properties, and then we have to apply for to the zoning and see if they can. Is there any way that we could do it beforehand to see if that possibility could happen or not?
So yeah, you can and you can call the zoning office in whatever the municipality is. Talk to the zoning officer.
Yeah, I think someone that they tried to call. They told them actually they have to apply for an application, fill out an application, and I'm not sure if they need
Okay,
a
so
blueprint.
yeah, in order to do any type of development or improvement of commercial property, you must
Yes.
have a site plan. You must submit a site plan.
Well, that's what I'm saying. So we can't really do that beforehand. It'll have to be after the fact.
Correct.
Basically. Yeah.
Yeah.
Okay.
Now,
All right.
what you
in
can
terms
do,
of,
let me just give you an idea. What you can do is make your offer to buy this property subject to getting whatever approvals from the municipality and the county you need to build whatever it is that you want to build, right? So
Yeah.
once you have the property under contract, you can apply for those site plan approval or whatever variances you might need. You just need the owner's permission and cooperation to sign off on. Your client could pay the costs of doing all this, and if he gets and you can make the contract subject to him getting approval for those permits or variances, whatever he needs.
well, the buyer is kind of interested in buying it regardless, but
Oh, he
he's
is. Okay,
hoping
we'll do it after the fact then. Yeah.
yeah,
Yeah.
yeah. He's just hoping that that will be possible. So this way,
Yeah. What town are you talking about?
in Clifton.
Clifton. Yeah, that's not far. Okay. Yeah. Yeah.
Yeah. Okay.
Yeah. Good.
Mhm.
All right. Anybody else? You see if I see anything? I don't see anybody else. Chats. All right. Well, we will get the message out again in a couple of weeks about next month, and hope everybody can make it back here again. In the meantime, please feel free to reach out to me direct if you have any questions or need any help or assistance. Just askinlaw.com. Yeah, go ahead.
Bill, I think land use and variances and zoning would be a great topic.
Yeah, you've got a big one going on right now.
Yeah.
Yeah. Yeah. All right. Maybe we'll do that. All right.
Okay.
All right.
Sounds
Have
like
a good evening,
plan. Thank you,
everyone.
Bill.
You bet.
Thank
My
you.
pleasure. Take care.
Thank
Great
you.
as usual.
Thank you.
All right.